Welcome everyone to Asking for a Friend, ERISA Fiduciary Edition. Thank you all so much for joining us. Our moderator for today's call is Beth Allen. She will be answering the questions you sent through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we're unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At this time, I'd like to introduce our speakers for today's call. Joining us today are Sarah Burns, Vice President and Counsel of Benefits Compliance at NFP, and Carol Wood, Vice President and Counsel of Benefits Compliance at NFP. Sarah, the floor is yours.
Thanks, Amber. Happy to be here today to talk about ERISA. How often do you hear that? Probably not very often. Before we get into the agenda, just a quick disclaimer here. So Carol and I, we're attorneys, but we're not your attorneys, and our benefits compliance team, we provide education and guidance on these topics, but we can't provide tax or legal advice. For that, you need to go to your own tax advisor, your legal counsel. Also note that these rules are changing all the time with new laws or with guidance, so this information is only current as of today, might change. Just a bit of housekeeping to repeat what Amber said. Beth Allen is here with us moderating, and we have the BC team standing by to answer any questions. Please put those in the Q&A, not the chat. And yes, again, the slides and the recording are going to be made available in a couple days. Okay, on to the agenda. So we're calling this webinar Asking for a Friend, really in recognition of the fact that these issues, they're confusing. Even for ERISA attorneys like us, you may be serving as a plan fiduciary, but uncertain about what that really means. And that's okay. We understand that these concepts are often discussed in technical ways, so it may be awkward to ask about what it means to be an ERISA fiduciary in plain English. So we're going to ask those questions for you with the goal here to illustrate what it means to be an ERISA fiduciary through some real-life examples that you may encounter as you deal with your own plans. Also note that we are only covering health and welfare plans, not retirement, which is also subject to ERISA. So on the agenda, we're going to start with a brief introduction of ERISA and the law's purpose, and then Carol's going to walk us through an overview of ERISA's fiduciary duties, who is a fiduciary, what the duties are, the consequences for violating these rules. That's referred to as breaching a fiduciary duty. But really all that means is violating ERISA in plain terms. And then we're going to present those common questions, those scenarios that we hear from employers, and discuss the different fiduciary duty considerations in each scenario. And our discussion's going to include how the recent Consolidated Appropriations Act of 2021 and some of those transparency rules introduced some new requirements that fall under the ERISA plan fiduciary umbrella. And then we're going to end with some takeaways and hopefully some time to address some great questions from the Q&A. So next slide. Okay, so just a little bit of table setting here. ERISA is a huge topic, and we're just focusing on one part of it today. Of course, that's the fiduciary duty side, but there are lots of other ERISA considerations, like the threshold question of which benefits are subject to ERISA. That's going to be, I'm going to say it very quickly, that's going to be your health, your disability, your life, your dental, your vision, your prescription drug, HRAs, health FSAs, and then exemptions from ERISA. Notably, that's going to be church plans and governmental plans like city, county, state plans, public schools. The interplay of the federal ERISA statute and state law, that's called preemption. That's a technical word for that. And then many other ERISA-related requirements. So handling plan assets. Plan assets are going to be like employee contributions or any amount held in a plan trust. The requirement to have a written plan document. We're going to talk a lot about why a plan document is important today, but there are other requirements related to that. And there's the annual Form 5500 filings and claim procedures. All of these things we can't get into today. And so for those topics, I'm not going to leave you hanging. We have a broader discussion on ERISA in this great NFP compliance publication right there. So if you haven't read it, I urge you to ask your advisor for a copy. Next slide. Okay, so let's talk a little bit about ERISA's purpose and some history for context, not a full history lesson, but just a little bit of context. ERISA was enacted back in 1974, so almost 50 years ago, and it was to protect employee pension funds, really to address the mismanagement of those funds. So that was back in 1974, but it's been amended many times since then, including recently with the CAA 2021. So it has been evolving, but it remains the main law for employer-sponsored health and welfare plans, and it's enforced by the Department of Labor. So if you hear us say the DOL, what we refer to is the Department of Labor, and that's the federal agency that enforces ERISA. So the purpose is to protect the interest of plan participants and their beneficiaries. And that's kind of twofold. The first prong is like transparency, right? So providing plan information to participants. And then there's the accountability. And the accountability has certain standards of conduct to follow. And that standard is the fiduciary standard, which is really high. It's among the highest in the law, and it's based on, well before ERISA, it's based on well-established trust law principles. And then with what it means to be an ERISA fiduciary, that's been specifically worked out by courts over the years and the DOL. And this quote there, I think it's a colorful way to describe the standard of conduct for fiduciaries in general, not just ERISA. So it's something stricter than the morals of the marketplace at a level higher than that trodden by the crowd. Very colorful. It comes from Justice Cardozo from New York, and then he was on the Supreme Court, and he is known for his flair and his opinions. In law school, we always heard about Justice Cardozo, and I liked the way that he describes it there. My point is that when enacting ERISA, Congress made this choice. They were thinking about the purpose to protect participants, and they chose to apply this very high standard of conduct. Okay, so with that bit of table setting, let's jump right into the who, the what, and the how of ERISA fiduciary duties, and I'll turn it over to Carol.
Thank you so much, Sarah, for that great introduction. And we'll move right in. We have a lot to cover. Good afternoon, everybody. We have a lot to cover in this first section, so just fasten your seatbelts. We're going to move fairly quickly, but we will leave some time for questions at the end of the presentation. So let's start out. Who is an ERISA fiduciary? An ERISA fiduciary is an individual or entity. It could be, for example, a committee who has or exercises discretionary authority or control over the management of the plan or plan assets. ERISA requires that a named fiduciary be specified in the written plan document, and the plan administrator is normally the named fiduciary with overall responsibility for plan compliance. The plan administrator can delegate specific plan functions to other service providers if it's allowed under the plan document. The plan sponsor is the default plan administrator in the absence of a designation. So putting this together, the sponsor employer normally is the plan administrator and has significant plan fiduciary obligations. But it's important to understand that ERISA fiduciary status is not based on designations alone, but on actual functions performed. So even if there's no designation in the document, courts will look at the actual functions of a party. As the Fifth Circuit put it, if it walks like a duck and talks like a duck, it's a duck. So a service provider that exercises discretion over plan functions can be a fiduciary with respect to those functions. With a fully insured plan, an insurer that determines plan claims and appeals is a fiduciary in that capacity. For a self-insured plan, the TPA or ASO may be deemed such if they interpret the plan and review appeals. Appeals are considered, review and determination on appeals is considered a fiduciary function under ERISA. Other service providers, such as health FSA vendors, are usually not fiduciaries because their roles are ministerial, meaning they play a non-discretionary role that is limited to following the plan administrator's rules and policies. That's a very important distinction there. So when does an employer act in a fiduciary capacity? Fiduciary obligations apply broadly to plan administrative functions, but not to what we term purely settler functions. ERISA's fiduciary rules are general in nature and affect every aspect of plan administration. But when an employer makes a business decision in relation to plan design, amendment, or termination, they are acting as settler, not as fiduciary, so their decisions are not governed by fiduciary rules. So just as an example, if an employer decides that they're going to terminate a benefit plan because it's too costly, it's no longer cost efficient, that's a business decision to do that. However, implementation of that business decision, which would involve notifying participants of the plan termination, that would normally be via the SBC or SMM, that is a fiduciary act. So distinguishing between settler and fiduciary functions can often be difficult. And when conducting affairs, employers should remember that they have what we say is two hats. They're playing these two different roles. And therefore, it's good practice to have separate committees and meetings to review plan business versus administrative matters. An important thing to keep in mind is that plan assets cannot be used to pay for the settler activities, those plan termination design activities. So what are the primary obligations of an ERISA plan fiduciary? In general, as Sarah was saying, an ERISA fiduciary acts in a position of trust for the benefit of plan participants and is held to a higher standard of conduct than in other business relationships that requires greater care in decision-making and significant disclosures. The main duties of an ERISA fiduciary are to act solely in the best interests of plan participants and beneficiaries. We call this the duty of loyalty. And as part of that duty of loyalty, plan assets must be used for the sole purpose of paying plan benefits or reasonable plan administrative expenses, and that's known as the exclusive benefit rule. And then the fiduciary must also avoid prohibited transactions, that's conflicts of interest, and we'll discuss that more in a later section. The fiduciary must act with the care, skill, prudence, and diligence of a prudent person in similar circumstances. That's the duty of prudence, and must act according to the plan document. Now, many common plan administrative situations are going to implicate more than one of these duties. So there is overlap here. It's not necessarily important that you understand which duty it falls under, since all of these apply to you as the ERISA plan fiduciary. So we'll discuss these in a little more detail now. How does an employer fulfill their fiduciary duty of loyalty? So the fiduciary must discharge plan duties solely in the interest of plan participants and for the exclusive purpose of providing plan benefits and defraying reasonable plan administrative expenses. So that sounds quite broad, and it really is. It encompasses so many things. But here's some examples here. This means the employer cannot use plan assets. And by plan assets, ERISA actually doesn't provide a definition, but it would include employee premium contributions and also any amounts held in trust. We know those are plan assets. So those assets can't be used to pay any of the employer's general operating expenses. The employer shouldn't allow their TPAs to use a practice called cross-plan offsetting. And this is when an overpayment has been made by a TPA to a healthcare provider, and then they try to recover one plan's overpayment by holding back another plan's payment. And that would violate that exclusive benefit rule. The employer must ensure that plan service provider compensation is reasonable. They should take steps to protect participants' personal data and guard against misuse. Yeah, there's a cybersecurity element that's coming into play here too. The employer must disclose material plan information to participants and recognize this duty may extend beyond distribution of SPDs, SMMs, SBCs, and providing documents when requested. So courts have found a fiduciary duty to provide information about plan amendments that are under serious consideration. If participants ask about plan changes, there may be some situations where there's an affirmative duty to disclose. And I think Sarah will be discussing that a bit later. So it's a very broad duty, this disclosure duty to participants and beneficiaries. How does an employer fulfill their fiduciary duty of prudence? A plan fiduciary must act with the care, skill, prudence, and diligence of a prudent person acting in a similar situation who is familiar with such matters. And that last phrase is kind of key because it's known as the prudent expert test, and the standard is objective. So this is not a situation where good faith is going to be good enough. This means the employer may need to engage experts if they lack the particular knowledge or expertise in the subject matter. The focus is always on prudence in the decision-making process. The result is less important. So a regulator or court would review how the fiduciary reaches the decision. An employer must also be prudent in the selection and monitoring of plan service providers. The DOL views selecting healthcare providers and networks as a fiduciary duty. So they must be prudent in the selection process, consider the provider qualifications, quality of care, and reasonableness of fees. The employer also has an ongoing duty to monitor all plan service providers for adherence to the contract terms and applicable laws. And it's important to emphasize here that the employer generally can avoid ultimate legal responsibility if delegated responsibilities are not properly discharged. These normally come back to the plan administrator. Why is it so important for an employer to follow the plan document terms? Well, that's a fiduciary obligation. They must operate the plan in accordance with the plan document. ERISA requires every benefit plan to be established and maintained pursuant to a written document. And the document must specify certain information, including the name fiduciary, a description of benefits, eligibility, funding methods, claim procedures, plan amendment and termination process. And the employer really needs to be familiar with the document terms to properly administer the plan. And these terms should be applied consistently to all similarly situated employees, because keep in mind the employer also has a fiduciary obligation to treat all participants in a fair, objective, and impartial manner. So making one-off exceptions that deviate from plan terms, let's say waiving a plan waiting period for a new hire, you're very sympathetic to their situation, that's actually a fiduciary breach. Plan changes should always be made by amendments with the appropriate notice, your SBC or SMM, provided to participants. And the employer must also follow all applicable laws in administering the plan, and this requirement is normally reflected in that plan document. Well, what happens if an employer breaches a fiduciary duty? Fiduciary breach can have very serious consequences for both the fiduciary and the plan. Potential consequences include inadvertent amendment of the plan. That's by making an exception and waiving that waiting period. Now the employer is setting an undesirable precedent that they're going to have to follow for other employees because they have the obligation to treat them in like manner. There can be DOL civil penalties. There can also even be criminal penalties if a failure is willful. Of course, lawsuits may result against both the plan and fiduciaries by participants seeking relief. We know litigation is costly and very undesirable from a PR standpoint, and the employer is going to actually need to engage counsel and take corrective measures. There also, and this may surprise some fiduciaries, there's personal liability of fiduciaries if the breach results in a plan loss or participant harm. And this is why it's important to have appropriate protection, be it insurance and or indemnification. Co-fiduciary liability can result if a delegated fiduciary role was not properly fulfilled. So it's very important, given all these consequences, that employers understand their fiduciary obligations and play by the rules. I know that was a long description, but it's always best to illustrate by examples. So I'm going to turn it over to Sarah to give some examples with classic fiduciary duties scenarios.
Thanks, Carol. Yeah, so now we know what the law says a fiduciary duty is. We know what the purpose behind ERISA's determining that the standard of conduct was going to be fiduciary standard of conduct. And so we're going to move into real life, how this actually plays out. And if we go to the first scenario here. Okay, so the question is, one of our employees was denied a claim for a surgery that's considered experimental under our plan. Meaning it's not covered, it's excluded. So if the member goes through the appeal and it's denied, can we just pay the claim? This is a question we get from time to time, essentially whether a self-insured plan can just pay the claim after some treatment was denied by the TPA. And it's an understandable question at a basic level. If you're thinking a self-insured arrangement just means that the employer is paying the claim anyways, why not just overrule the TPA and pay it whenever they want? But the thing is, that's not how ERISA works. It's the ERISA plan with both employee and employer contributions, not the employer paying the claim. And the ERISA plan is a separate legal entity. It has a life of its own, right? There are strict rules to follow, primarily the plan terms itself. That plan is going to be your instruction manual on what's covered, and the TPA's instruction manual on what's covered and what's excluded. In this scenario, it seems like that would be a certain surgery that would be considered experimental and excluded for that. But the employer, as a fiduciary of the plan, needs to follow those plan terms. So paying a denied claim in this scenario, it risks going against those plan terms, violating ERISA, also known as a breach of fiduciary duty. So another consideration on just paying the claim is that it can set precedent, that other employees may expect the plan rules would be bent for them in similar situations. If they had another treatment that was denied as experimental, let's say, and it could be an issue with your plan's stop loss insurer. So basically, if the plan gives the TPA the authority to decide the claims, meaning they are the claims administrator and the plan says that, then part of following the plan terms means deferring to that authority. So that's the duty to follow the plan terms. However, there's another duty. The fiduciary duty, it also includes the need to monitor the TPA, that the TPA is following the plan terms correctly and the appeals process correctly. So there's really two sides to this. Still doesn't mean that an employer can just step in and overrule a TPA and claims decisions whenever they like. But if there's some doubt that the TPA is deciding claims inconsistent with the coverage terms, or there's some problem with the appeals process, that's definitely something you're going to want to review with legal counsel. As a self-insured employer, you can have fiduciary liability for your TPA's mistakes, and it's important to monitor what they're doing with the claims process. So the takeaway here is that you need to be careful about being seemingly generous through making exceptions, and you're going to want to review these situations with legal counsel and consider whether paying the claim is, on the one hand, breaking the plan terms, right? Covering or paying a claim for a service that may be clearly excluded, or on the other hand, whether there's an issue with the TPA's claim procedures or appeals process that needs to be addressed. So that's the first scenario. We want to go into the second one. Okay, so is there a penalty for not disclosing Medicare Part D notices? And you may think that we've lost the plot here because we're talking about ERISA and not Medicare Part D notices, but I'll get to the point. Obviously, it's a timely question given that the Part D notice disclosures were due earlier this week, October 14th. That's prior to the annual Medicare enrollment period. Just a reminder that the Part D disclosures, they inform about the credible status of a plan's prescription drug coverage. That means whether the group coverage pays benefits at least equal to Medicare Part D. So yes, it's true that there are currently no specific penalties for failing to provide a notice under the Medicare statute, but ERISA plan fiduciaries have an implied duty to comply with federal laws related to their benefit plans. So this means that there may be ERISA penalties for incorrect notices or just not providing the Part D notices at all. If you step back and think about the purpose of the notice, that's to provide really important information to participants, to eligible individuals. If Medicare eligible individuals end up delaying enrollment in Part D because they got bad information or they got no information about whether their coverage was creditable, they face a penalty, a personal penalty, when they enroll in Medicare. That's because Medicare eligible individuals can only delay Part D without penalty if they have that creditable coverage. So here, I don't really know that the ERISA fiduciary considerations fall neatly into one box, the duty of loyalty, or maybe another, but it's really about just acting in the best interest of participants. Let's call that the duty of loyalty. And this is information that's really important to certain participants, to certain potentially eligible individuals. So there's that duty to just disclose accurate plan information. Bottom line is that there is some ERISA risk in not providing these Medicare Part D notices, and you could face penalties under ERISA, potential lawsuits, DOL enforcement. So that's the Medicare Part D scenario. We can move on to the next one. And this is about life insurance. So ERISA governs group life insurance plans too. It's not just health. And in this question, it's about we sponsor a group term life insurance plan that includes a conversion right upon termination of coverage. Are we responsible for sending terminated employees a conversion notice? So when it comes to group life insurance, I'd say this is the most common question that we get. Start with a quick description of conversion rights. So typically group life insurance coverage, that's going to end when active employment ends, but there's often a right to convert the group coverage to an individual policy built into the plan. And that right to convert is often without evidence of insurability or proof of good health. So it may be cost prohibitive for some, but worth it and critically important for individuals who are otherwise uninsurable for individual policies. Think like terminally ill employees who need to stop work, so they're terminated from employment and then they lose their coverage. The right to convert to an individual policy would be really important to them, right? But the thing is, this question that we get, like, is there a notice? ERISA doesn't directly require providing life insurance conversion notices, but there's the duty to follow the plan terms. And the plan terms may very well tell a participant that, hey, you're going to get a conversion notice from your employer when those rights are available, like if coverage is terminated. The carrier agreement could also put this requirement on the employer. Or the plan could say something different. It could say that the carrier is going to provide the notice. It varies and it depends on your particular plan. So the first step as an employer sponsoring a life insurance plan, as an ERISA fiduciary, is to understand what notice, what delivery duties you may have under the plan, if any. And then this scenario, it also brings up a related issue of responding to questions about life insurance coverage. So on this, it's really important to have consistent procedures to respond to information requests. Carol mentioned before an affirmative duty. So to inform, so courts have held in a few different life insurance cases that there may actually be an affirmative duty to inform based on the circumstances. And a simple example of this would be a recently terminated employee asking a very general question, like, do I have conversion rights? Just saying yes, even though it's accurate, it might not be enough because these conversion deadlines are super strict. And I think you can imagine why. And they're also very short windows. So an an employer as a fiduciary may need to provide more complete information than just like, yeah, there's a conversion right, but you have to provide, additional information on how to convert and when to convert. And the same goes for other questions on coverage, like when eligibility ends, when it begins, whether evidence of insurability is required. So to guard against this, it's best to designate certain individuals who have knowledge of the life plan. They're going to be the ones to respond to these questions, right? It's likely someone in your HR department or you on the call. And then provide the plan document in response to these questions, even if it's been previously provided at other times. It's always best to provide it when you're responding to these questions as well. We don't have an image of it here, but note we do have a NFP publication, a guide for employers on life insurance administration. So if you have more questions about this scenario, ask your advisor for a copy of that. Okay, what's the next one? Leaves. with the picture of leaves there, very literal. It's also just a pretty picture. Okay, so this is another common question. The question is, if an employee doesn't return to work following FMLA or protected state leave, can we just keep him on the medical plan for as long as he continues to pay his premium share? So this is another good example of how thinking you're being generous may actually be breaching a fiduciary duty. That's because of the duty to follow the plan terms. So the plan terms are going to dictate when coverage ends. And it's important for all your employee communications, your leave policies to be consistent with those plan terms and approved by your carrier. And I say approved by the carrier because if an employer allows an employee to stay on a plan for longer than the carrier has allowed, you're risking self-insuring a claim during that extended period. And if we're talking about someone on medical leave, you can imagine that those claims would be pretty significant. They need a lot of medical treatment. We always say that a solid leave policy is really important because it avoids, for many reasons, but one reason relevant here is that it avoids deciding these things on a case-by-case basis, those one-off exceptions. You really want to avoid them because they're problematic under ERISA. So fiduciaries and employers need to be careful not to promise more than what the plan actually allows. And a quick note here that COBRA may be triggered on extended leaves of absence when benefits are terminated due to the plan's eligibility terms, right? It would be a reduction in hours under COBRA. And then there's a related question that we get is, what about the other benefits, the disability life benefits? When do they end when someone's on extended leave? Well, the answer is basically the same. You're going to follow each respective plan's terms. The plan, that's your instruction manual, and you need to follow it. Okay, scenario 5. So very timely because it is MLR rebate season, right? The leaves turn and we're getting MLR rebate. So the question here is, we received an MLR rebate check. Since our plan's premiums are mostly employer paid, can we just keep the refund? Like, is there some de minimis exception? Let's start with a quick note on what an MLR rebate is. It stands for medical loss ratio rebate. And the ACA requires insurers to pay these to policyholders by each September 30th if the insurer spent less than a certain percentage on premiums of claims during the prior calendar year. So I like this scenario, I like this question, because I think that it provides a nice example that hits on a few different fiduciary duties, whereas the other examples we had kind of hit on 1 or 2. This hits on, I'd say, 3. And that's because we're talking about plan assets here. Yeah, in this scenario, the employer seems to have paid for most of the premiums, but not all. So the portion of the MLR rebate that's based on participant contributions, those are plan assets that belong to the plan and the plan participants. So the duty of loyalty, that's the first fiduciary duty that's triggered here, says that the employer can't just keep plan assets, which is a portion of the MLR rebate in this scenario, right? That's from the employee contributions, even though it's small. So this means that the first step is to determine what portion of the rebate are actually plan assets. And then the next step is to look at the plan, right? Your instruction manual. There's a duty to follow the plan terms. When trying to figure out what to do with the rebate, check to see whether the plan is going to give you that direction and then follow those directions. Now, if the plan is silent on what to do with the rebate, which it very may well be, then you need to make a fiduciary decision. So that's following the duty of prudence, which sounds very technical, and we have it written there, but it's just basically make a reasonable and fair decision based on the circumstances, right? So for that, because the circumstances are going to vary, we have some guidance from the DOL. And one example says that if a rebate amount is small, like it seems to be here, then it may be okay to only distribute to current participants rather than spending all the resources to like track down the former participants and mail them the rebate, right? That costs money. And it may be, it may cost more to do all that. It may cost more than the rebate's actually worth. So the other question in dealing with rebates is how to actually distribute it once you've determined who you're going to distribute it to. Like, is it going to be a refund check, premium reduction, benefit enhancement. You need to distribute it within 90 days of receiving it from the insurer, but you have different options. So what to do with the rebate, it really comes down to the facts and circumstances and making that prudent fiduciary decision, or that fair and reasonable decision. And you want to take into account different things, like we talked about, the amount of the rebate, who your participants are. The examples from the DOL, they're helpful, they're not necessarily exhaustive. If you have like certain unique circumstances, or say you've got a really large refund, it'd be a good idea to talk with legal counsel. I know there are other considerations on MLR rebates, and we could spend, at least half an hour going through it. But the interest of time, we're just going to defer to that guide that's there on the slide. It's a step-by-step guide to help make this fiduciary decision, and some other considerations with MLR rebates. So please ask your advisor for a copy, because it certainly is timely right now. Carol, anything to add before we move on to the next section?
No, I think that's it, but I agree with you. I think like an MLR rebate is a perfect example of all the fiduciary roles. It's the ultimate discretionary decision, right? Just taking all the different factors into account when there's no clear-cut guidance, and just weighing the different interests of participants, and then making the decision that only at the end of the day the plan administrator can make.
Right.
Okay, so with that, then I'm going to move forward to our next section, fiduciary considerations in an evolving world. We often think of ERISA as this old stuffy statute, right? And it's important to realize that, well, the fiduciary obligations have always been there and they remain. How they apply where there's new regulations and in our evolving world can be very different, and we need to be open to considering that. And we're going to provide a few examples now. So here's a question involving the CAA. Can a self-insured group health plan rely on a TPA for the new Consolidated Appropriations Act compliance items? This would include, for example, the gag clause attestation, the mental health parity NQTL comparative analysis, surprise billing disclosures, RxDC reporting, oh my. And we know, just a reminder here, that insurers are also subject to these requirements. So fully insured plans can contract with the carrier to assume liability for satisfying many of these requirements. But self-insured plans, although they can contract with a TPA or other service provider for assistance in fulfilling the requirements, the legal compliance obligation remains with the plan. So what are the fiduciary considerations here? Now, we do know that ERISA permits the plan administrator to delegate certain functions to a service provider in accordance with the plan document. The plan administrator, though, the duty of prudence requires that the plan administrator use responsibility when selecting the service providers and ongoing and monitoring them on an ongoing basis to make sure they're adhering to the contract terms and applicable laws. And even if plan obligations are delegated, the self-insured plan, as we said, cannot avoid liability for compliance if the delegated responsibilities are not properly discharged. And what we mean here is that from the standpoint of the federal regulators, they're going to focus on the self-insured plan and the plan fiduciaries. This doesn't mean that under your service provider contract, there may be certain monetary protections for the plan, and I would argue there should be if the contract was well negotiated, for example, indemnification, so that if a service provider fails to perform, there's some perhaps monetary relief if you're sued by a third party. But that's really between the plan and the service provider under the state law the contract is written under. The regulators are going to just look at you if the obligation isn't satisfied as the plan fiduciary. Okay, so how do we navigate this roadmap with all these requirements that we're ultimately responsible for? Well, we need to recognize that, and that choosing to rely or not rely on the TPA for any requirement, and we'll use the example of the gag clause attestation, their assertion of compliance with that. Can I rely on it? That's a discretionary decision to be made by the plan administrator. It's also important for the fiduciary to assess when the duty of prudence may require consultation with an expert. For example, the mental health parity and QTL comparative analysis is very complex. It's very detailed, it's very complex. If you're reviewing that to determine if it's sufficient, and there are proposed rules of course that may require the plan fiduciary to certify that it's compliant, well, that's a situation where maybe prudence would warrant consulting with an expert to make sure that you're meeting the actual requirements. It's also important to select appropriate plan service providers, monitor their performance, and ensure that all of the delegated obligations are clearly addressed in a written contract. So it's preferable for the RFP and any resulting contract to actually specify those obligations rather than just saying complying with applicable laws, which most contracts state. The TPA will adhere to the No Surprises Act provisions when deciding claims and administering the plan. They'll submit the RxDC, the upcoming air ambulance reporting on the plan's behalf, provide the mental health parity comparative analysis, and so forth. The contract should also reflect fiduciary rights to monitor, meaning that the fiduciary can audit the TPA services, usually it's limited to once per year, access periodic reports. Maybe they want some claim statistics to see if the surprise billing provisions are being properly administered, or copies of regulatory reports, a confirmation that the RxDC reporting was submitted. So those should also be reflected in the contract. Monitoring should also include investigation of any participant comments or complaints about the services. And be aware that the DOL has provided tips. The link is in the slide deck that you'll be receiving, tips for selecting and monitoring service providers. Of course, none of these measures are going to relieve the self-insured plan of possible liability, but let's certainly put them in a better position to achieve compliance and fulfill their obligations. Okay, moving to another CAA requirement. We received a 408B2 statement. What is this and what should we do with it? And just to backtrack here, this involves prohibited transactions. And the prohibited transaction rules are broad. So they broadly prohibit the funding of any goods, furnishing of any goods and services between a plan and what's termed a party in interest, which would include a service provider. So basically, just under some of the prohibited transaction provisions, the furnishing of goods and services to the plan by the service provider is prohibited. It's a prohibited transaction. That's why we have Section 408B2, which provides an exemption from that prohibited transaction. And Section 408B2 says that this transaction is allowed provided that the services provided by the service provider are necessary for the plan, and that the compensation provided to that plan service provider is reasonable. And this has always been the case. This is not anything new. However, the Consolidated Appropriation Act added an additional requirement that in order to avoid a prohibited transaction, the group health plan, service provider, broker, consultant, etc., must fully disclose their compensation in writing to the plan in order for the arrangement to be considered reasonable. So this is a very important requirement. Now, in the retirement, with retirement plans, it took effect back in 2012, so it's really nothing new there. Service providers to retirement plans have been required to provide a written disclosure of their compensation, but it's new for group health plans, and it's important to be aware of the importance of receiving it and reviewing the statement. So what fiduciary considerations come into play here? First is the duty of loyalty. The fiduciary must act solely in the interest of participants with respect to the plan and plan assets, and must avoid prohibited transactions. And the fiduciary is also responsible for selecting and monitoring plan service providers as part of the duty of prudence. And so what more specifically can the plan fiduciary do? Well, first, make sure that the disclosure is received before entering or renewing a group health plan contract. Send a written request to the service provider for a copy if it's not received. And if it's not received after 90 days following a written request, consider reporting it to the DOL. Review the disclosure and request any clarification or additional information needed. It should describe the services, whether the service provider is a fiduciary, and all compensation and the form in which it is received. And you would need to evaluate the service provider's compensation using the disclosure to inform the analysis. Some sort of market check is involved here, but prudence doesn't necessarily require that a selected service provider be the least expensive. They just need to be a good fit to address the particular needs of the plan and the plan participants. The review should be documented with a copy and the disclosure retained for your records, and then make sure that you establish a process for ongoing compliance prior to entering or renewing applicable contracts. What about the transparency and coverage rule requirements, or TIC? What about the TIC requirements? Are there any related fiduciary considerations? And just to review here, the transparency and coverage rule was enacted just before the Consolidated Appropriations Act. Back in 2020, it was finalized. And it focuses on transparency in healthcare pricing with two basic requirements. We have the public posting of the machine readable files. This would be the in-network negotiated rates, out-of-network allowed amounts and billed charges, and also prescription drug negotiated prices. The prescription drug prices is new. Enforcement was postponed, but the regulators recently announced that the enforcement is no longer going to be delayed, and so we expect to receive further information soon as to when the prescription drug prices will need to be posted. Disclosure of plan cost sharing information to participants via an internet self-service tool is the other requirement. So this is really a form of disclosure to participants. Some term it similar to an EOB in advance, where the participant would receive information about a healthcare service that they may be planning to receive and an estimated cost from different providers, taking into account in real time the amounts they've already applied towards their deductible or out-of-pocket amounts. Like the Consolidated Appropriations Act, these requirements apply to carriers as well as group health plans. They fully insured plans can contract with the carrier to assume liability for the disclosures. But again, self-insured plans, although they can contract with a TPA or service provider, the compliance obligation remains with the plan. So what are the fiduciary considerations here? Well, first, the duty of prudence. The plan administrator is responsible for service provider selection and ongoing monitoring. We've already discussed this. They're also responsible for ensuring plan assets are used prudently for the purpose of paying plan benefits. And this would come into play with really the result of the posting of those machine readable files. The whole purpose behind those files was to, in the disclosure, was to create a more competitive market. You know, if there was transparency, the prices where everybody was aware of the different plan prices, these information would be compiled in reports that plans could then use to benchmark the prices they were receiving and to negotiate better prices for their plan. So that's where, and if the participants are paying a portion of the contributions, we have plan assets. So it's important to make sure those plan assets are used prudently. We're not paying more than we need to for the services. Duty of loyalty also comes into play here. The plan administrator has an obligation to provide participants with adequate information in an understandable format to enable them to make informed and course-conscious decisions regarding their plan benefits. Just to look at this a little more specifically, in addition to selecting and monitoring appropriate plan service providers, what else should the fiduciary do in terms of monitoring? Well, we know we have this new prescription drug posting requirement that's going to be enforced. So it may be appropriate to reach out to the carrier TPA to make sure that they're aware and they're timely going to be posting that information. Also, the same thing regarding the full implementation of the Internet self-service tool. That's for plan years beginning in 2024. It was phased in 500 items and services for 2023, but fully implemented in 2024. And recognize that with this Internet self-service tool, as I said, it's actually a form of disclosure to participants, right? We're normally thinking of our SPDs, SMMs, but this is, in the new era, really a form of disclosure. So review the tool, make sure it satisfies the applicable requirements. One of the requirements, and I think a particularly important one, are the disclaimers. Disclaiming that the information is only an estimate. And this was a particular concern, I know, of plan sponsors in comments, that participants would be using this tool and getting these prices for the services, and then lo and behold, they'd receive the services and receive a bill that was quite different than that estimate they received. So that's something I think I would want to look at as a plan sponsor. Like, what, how are these disclosures? What are the disclaimers? Are they very clear to participants so we don't have any issues and disgruntled participants? Consider also whether there are adequate, understandable instructions available to participants so they can effectively use the tool to compare healthcare cost. So those are just some examples. Do ERISA fiduciary duties extend to cybersecurity? This is a really interesting question, and it's one that the DOL has been focusing on increasingly in recent years. They've been looking at cybersecurity measures. Back in 2021, the DOL provided cybersecurity program best practices and also tips for hiring a service provider with strong cybersecurity practices. And there was confusion when these practices and tips were first released, and many thought, well, they just applied to retirement plans. They were not intended for health and welfare plans as well. In March of this year, the DOL issued a cybersecurity report specific to health and welfare plans, and they indicated no, those best practices and tips are intended for health and welfare plans as well. And there were a lot of comments they had gotten from the industry, basically saying that the DOL needs to provide more clear guidance as to the cybersecurity measures and documentation that they think is necessary. We know HIPAA applies to group health plan benefits, so asking for clarification on that. So hopefully we'll receive additional guidance, but we do know it's becoming more and more of a focus of the regulators. And if you do want to see that report from earlier this year, please visit our Compliance Corner article from March 14th. So fiduciary considerations that come into mind here: the duty of loyalty. The fiduciary must act solely in the interest of plan participant and beneficiaries, and also the duty of prudence to act prudently to protect the plan and plan assets. And I think that's a good example of how in our evolving world, it's very dynamic, and these new rules and regulations come out. We need to just keep adapting and thinking of those fiduciary obligations and how they're applying to new communication mediums and to new regulatory requirements. And with that, we're at our conclusion. So I'll turn it back to Sarah to give some final takeaways.
Yeah, thanks, Carol. So here's a list of some practical takeaways from the scenarios we discussed today. Number one, if you are a sponsor of an ERISA plan, you are likely a fiduciary, and you really need to take those responsibilities seriously. A plan document is important, very important for this purpose and other purposes, but it will help identify fiduciaries and delegate their responsibilities, like, is the TPA a claims administrator, or is the carrier handling life conversion notices, or is that on the employer? And along those same lines, we talked about why it's crucial to know your plan terms and administer them correctly. Think of the plan as your instruction manual, and you need to follow those instructions when you have your plan hat on. Making those exceptions, right, for a claim or for extended leave, even though it could be in the spirit of generosity, right? You're trying to do what you think is the right thing. It could actually be a fiduciary violation and get you into trouble in different ways. Do not forget to monitor your service providers. A couple of examples that we gave were the TPA and the claims handling and appeals process. Are they administering the coverage terms as intended? Are they following the correct appeals process, giving participants the rights that they are due under the plan? And then those broker compensation disclosures to make sure that you have those. Remember that plan assets belong to the plan, not the employer sponsoring the plan. And that MLR rebates scenario, MLR rebates in general are a really good illustration of this concept, right? If it's a plan asset, employee contributions, namely there, can't go back just to the general, the employer's general assets, right? It needs to be shared with the participants. So always take care to provide participants with accurate and complete information. Like in the case of the life conversion question, this could include providing more information than what's specifically asked for. Like if there is a critical looming deadline, and ignorance is an excuse there, right? Again, going back to you need to know your plan. You need to be able to provide pertinent information to your employees when they ask about it. ERISA fiduciary duties, they're broad. It may mean complying with other federal benefit laws like the CIA 2021, those new transparency rules, different plan notices, mental health parity. ERISA is folded into that. And then finally, you know, while self-insured plans, yes, they generally are going to have more fiduciary responsibilities. Fully insured plan sponsors are also fiduciaries. And we illustrated that through several examples with the MLR rebates, life insurance, conversion notices, Medicare Part D notices, and then, of course, leave eligibility. Carol, I'll ask if you have anything to add, and if not, we can see if Beth has anything to add or any question from the Q&A.
Yeah, no, I think it'd be great to take some. Beth, do we have any questions?
Sure. I mean, we got some pretty specific questions. There was one on the front end that asked about situations where, for example, you have people have to make elections, and let's say someone failed to make their election and came back later and wanted to now, you know, potentially make an election or change an election, and whether or not that would be a violation of ERISA. And so do one of y'all want to take kind of a stab at that?
Sure. I mean, I think it depends on the particular benefit, right? If it's a health FSA or a benefit that's subject to ERISA, it could be a violation of ERISA and that's, you know, document terms, but it's probably more to, you know, a violation of the cafeteria plan terms to make an exception. But I think, you know, ERISA's application to ERISA plans, it would be, I would consider it a violation of the eligibility terms and the failure to treat all participants in like manner if you do make an exception. Now, sometimes in some cases, the exception is made before the plan year starts, and it's really just more of a limited exception. But if it's really violating the plan rules, I think that would be problematic.
Absolutely. And that's kind of what I got to in the answer was basically like, you know, I think the point y'all were trying to make is that, you know, you might have other requirements as a plan sponsor under different laws, where if you violate those, that could be considered a fiduciary breach, right?
Right. Yeah.
So I think that that's a fair answer. It's 3 o'clock or 2 o'clock, depending on what time you're looking at here in the country. And so we're right on the hour. Amber, do you want to close us out here?
Yes, thank you so much. Thank you, Sarah and Carol, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recording in the follow-up email and on the NFP website. If there are any portions of this call that you missed, by Monday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you, everyone, for joining us, and have a great day.